is to share with you some recent thinking and ideas with respect to the role that in-house counsel or party representatives in general can play in arbitration. I welcome your questions as we go along. Don't feel obliged, but don't feel shy. If as we're going through there's something I say that you'd like to, you can think of me as like a computer. You push the button and you can get more details on a particular point. So don't hesitate to do so. Otherwise, I'll just keep on going, and then you can ask your questions at the end as you prefer. So I think the point here is that I would like to share with you today some of the current thinking regarding how to effectively manage an arbitration in terms of time and cost. And so what I'd like to do is examine the various factors with you, factors that affect the time and cost of arbitration. And then after we've gone through that, we can analyze the steps that we've taken to address these questions of time and cost. So I'll begin by looking at these factors that affect the time and cost and looking at them in light of the inherent nature of arbitration itself. Now, what is the inherent nature of arbitration itself? Well, it's a dispute resolution mechanism that provides a certain number of advantages compared to litigation before national courts. For one thing, it's available to global users based upon their own agreement to submit the disputes to arbitration. Now, this is very important because in arbitration, you can agree to a particular set of rules in a particular place and pick what you want, rather than having a situation where you may not be able to know where you're sued, or if you want a particular jurisdiction and you have a forum clause, many jurisdictions will not recognize a forum clause if there isn't a specific link or a sufficient link to the country in question. Arbitration also provides a neutral forum in which the parties can select their judges, they can select their arbitrators, and they can agree on the qualifications that the arbitrators have. When you go to state courts, you get whatever judge happens to be assigned the case. If you have a complex technical case on some engineering subject in arbitration, you could pick arbitrators who know something about that. If you're in a national court system, you'll get a judge who may not know anything about the technical aspects of the problems of your case. Arbitration also provides a uniform system of enforcement under the New York Convention on the recognition and enforcement of arbitral awards. There are other treaties that govern enforcement, and domestic laws govern enforcement. It's sort of a peculiar thing, and I sort of like to mention this. The United States, for example, is a party to the New York Convention. So you can enforce an arbitral award rendered in Russia in the United States as a matter of public international law. But the United States has never ratified a single treaty on the recognition of foreign judgments. So if you have the judgment of a foreign court, you cannot enforce it in the United States as a matter of public international law. It will be enforceable, but as a matter of domestic law, the law of comity under the Constitution. So ironically, an arbitral award in the United States can be enforced under public law, but not a decision by a national court. Also, arbitration allows for more confidentiality than would exist in national court proceedings, which are open to the public. Arbitration proceedings can be confidential. And finally, arbitration, and this leads us into our topic, arbitration provides great flexibility that allows the parties to tailor-make the procedure in each arbitration to suit the needs of their particular case. Now, despite all these advantages that we can see to arbitration, many arbitration users have complained that arbitration has gotten too long, too expensive. One user who approached us, when I was in my role as chairman of the ICC Commission on Arbitration, said, "How can it be that it can take only 1 year to build a suspension bridge, And it can take 4 years to determine who was responsible for defects and delays. There's something wrong about that. And you know, there is something wrong about that. And so the question is, what to do about that? How can you do something about that? And what role can you play? What role can in-house counsel and the parties play with respect to this? And that's what we're going to start delving into more right now. So, as an anecdote, many years ago I was serving as an arbitrator in the Willem Wies Moot in Vienna. And there was we have these cocktail parties before the moot. Maybe some of you have attended the moot. And there was a cocktail party at which Lord Mosle, Michael Mosle, gave a talk. And he said, I'm going to give you a snapshot of arbitration 50 years ago when I started, and a snapshot of arbitration today. And he said, well, 50 years ago, arbitrations were very informal, it was very quick, it was very inexpensive. True, the cases were not these big amounts that they are today, but it was a very manageable process. And therefore it sold itself as being something quicker and more efficient and less expensive than court proceedings in many jurisdictions. Today, 50 years later, you have arbitrations that can last 5, 6, 7. I had one that lasted 10 years. And the costs have gone up considerably. And he said, you know, arbitration is an extremely valuable tool for all of these advantages and reasons that I've explained to you. And everybody knows that. But he said, unless something is done to deal with the problem of time and cost, arbitration is going to lose the following of the users, and someone ought to do something about that. And I was standing in the audience, and I said, he's right, somebody ought to do something about that. And I said, wait a minute, I'm the chairman of the ICC Commission on Arbitration. I can do something about it. And I decided right at that moment that I was going to do something about it, and I did. I created a task force on time and cost in arbitration. I spearheaded new elements in the ICC rules of arbitration to deal with issues of time and cost. And I conceived and was the primary author of this document called Effective Management of Arbitration. And so that's what I'd like to share with you this evening, to tell you about how we went about this and where we came out and the practical way that this can be done and what the implications of it are. Well, the first thing we did is we started out to see, well, you know, time and cost. The first step was to get a grip on the facts. If you don't start with the facts, you know, where are you? So we started with the facts, and we did a study of 3 years of arbitration statistics in the ICC, because that's what we had available to us, relating to final awards. And this statistical study showed the following breakdown on the average of the costs of arbitration. The costs borne by the parties to present their cases, and this includes not only lawyers' fees and expenses, but also expenses related to witnesses, expert evidence, costs incurred by the parties themselves, 82% of the total cost. Arbitrators' fees and expenses, on the average, 16% of the total cost. Administrative expenses of the ICC, the institution, 2% of the total cost. Well, once you get a handle on those facts, it becomes evident that the lion's share of the cost of arbitration is the cost borne by the parties to present their case. And thus, any attempt to control the time and cost is going to have to focus seriously on the question of the cost of the parties' presentation of their case. Now, rules of arbitration, in fact, this little booklet contains both the arbitration rules and the mediation rules. So the arbitration rules are only roughly half of this little booklet. And the rules of arbitration can be and are that short and that simple, because put simply, they don't specify how an arbitration is to be conducted. They lead the horse to water, but they don't tell the horse how to drink. For example, there is absolutely nothing in these rules, or the exit rules, or the UNCITRAL rules, or the LCIA rules. There's nothing in them that tell you how many rounds of briefs you should have. There's nothing that tells you the length of the briefs. There's nothing that tells you anything about the timing of submission. There's nothing, literally nothing, about document production. Nothing about bifurcation, when there should be, whether there should be. It permits it, but it doesn't tell you anything. There's nothing about the examination of witnesses, whether there's cross-examination or not, and how you examine witnesses and what that's all about. There's nothing about oral argument. There's nothing about post-hearing briefs. Well, you can sit here and say, well, then what's the use of these rules? They don't tell you anything about how the arbitration should be conducted. But of course, this was done on purpose, because the open-ended nature of the rules as to the actual conduct of the proceedings, as opposed to the issues of jurisdiction and process and the structure in which the arbitration occurs, was done on purpose to enable the parties and the tribunal to create what I like to call a tailor-made procedure that's appropriate for each case and that corresponds to the needs of the particular case. Again, if you compare the Federal Rules of Civil Procedure, the Russian, I'm sure, Code of Civil Procedure, like the French Code of Civil Procedure, it applies to all cases across the board. It has to follow this procedure. In arbitration, there is no required procedure. You make it up for each case, if you do it properly. But what we realized was that often this tailor-making process does not occur. Either the arbitral tribunal sends out a boilerplate procedural order number 1 that contains all of this stuff in it and we just go on, or you make it up as you go along. As the arbitration proceeds, you decide what the procedures should be, rather than starting out at the beginning and arriving at a process to establish for each arbitration an appropriate procedure. And an appropriate procedure is always going to be a procedure that is commensurate with the complexity and value of the dispute. And so we realized that this was the focus. The focus was how to deal with the costs of presenting a case and how to deal with establishing and how to encourage and create a basis for establishing a procedure that really makes this tailor-making occur as it should. Now, let's be very clear about one thing. What is the goal of every party in arbitration? The goal is to win the case, of course. The goal is not speed and low cost in and of itself. If it costs more and you win the case and you get all your costs back, you're not going to cry. If you lose the case, you're not going to be happy. So it's all about winning the case. It's not really about time and cost as an end in itself. On the other hand, you have to see that the appropriate time and cost for a given arbitration will always depend on the importance, complexity, and value of the dispute. Obviously, when 1 billion euros are at stake, parties will be more risk averse than if 1 million euros are at stake or if 10,000 euros are at stake. So again, the appropriate time and cost is going to be related to what's at stake. And as a result, to ensure an efficient procedure that's commensurate with the importance, complexity, and value of the dispute, conscious prior procedural decisions have to be made. And this brings us to the crucial question. How can the tailor-making of the appropriate procedure be achieved as a practical matter? Well, the first step, of course, is that each party has to sit down and determine for itself what it considers to be the optimal procedures that it needs in order to make the case and have its best chance to win. And obviously also, the more procedural steps you add, the greater the time and the cost of the arbitration. For example, now it's much faster and cheaper to have only one round of briefs instead of 2 rounds of briefs or 3 rounds of briefs. It's faster and cheaper to have no document production at all. It's faster and cheaper to have fewer witnesses, or to have a short hearing instead of a long hearing, or perhaps even no hearing at all and have the case decided on the documents. All of that will enormously reduce the time and the cost of the arbitration. But this is the key point that is important to understand. Each time you opt for a cheaper or shorter option, you're inevitably giving something up. You know, in this world, we don't get anything for free. You know, if it's going to be cheaper and faster, you're going to be giving up certain procedural steps. But then the question is, do you really need those steps in order to make your case? Is the potential benefit of these opportunities worth the cost? And so this I submit to you for your consideration. This is ultimately more of a business decision than a legal decision. It really turns on the question of a cost-risk-benefit analysis. Is the cost of having this additional procedure worth, in your best judgment, the potential benefits that it can give you? If it isn't, you should try to get rid of it. If it is, you should push for having it. And so when each party has made separately its analysis and judgment calls on these optimum procedures, then the parties at a very early stage can contact each other, and they should. You know, this idea of opposing counsel being enemies that can't talk to each other is not really in the interest of having an effective procedure. Counsel will obviously not give anything up that's in the interest of their clients not to give up, but there are some things that can be in mutual interest to agree upon to save time and cost without giving up your chances of success. And so if the parties can contact each other in the early stages, and I do this all the time, I contact the other side and say, let's see what we can agree upon here. And if we can agree upon certain things, then that's what will be applied. The tribunal almost always goes along with what the parties agree, and under the ICC rules they have to. Under other rules they don't have to, but they do. And so if the parties can agree on these procedures, then that's what will be applied. If they can't agree, then they go before the tribunal. Each side presents the reasons why, yes, we have to have 3 rounds of briefs. No, 1 round of briefs is enough. And then the tribunal will decide, after hearing the parties, and establish a coherent procedure. Now this is all well and good, but it raises yet another practical question. How, it's nice to say, all right, all of you are going to go and sit down and decide, you know, what is in your best interest in terms of the procedure, how many rounds of briefs, this, that, and that. But how do you actually go about determining the optimal procedure? How do you make this cost and benefit analysis? How do you make these judgment calls? And who can most appropriately make these judgment calls? Now, I submit to you that the problem is this. Outside counsel, which is the role I always play, other than arbitrator, which is something else. Outside counsel has a professional obligation to zealously represent its client. And it can be very delicate for outside counsel on its own to sit there and say, well, you know, it'll cost a lot of money to have the document production, and you know, maybe there's a 15% chance that it'll yield something good, but you know, so I'm going to say, well, no, we're not going to have document production. I'm going to give up the 15% chance to save the cost of the document production. And then it turns out later that there was a smoking gun that we didn't get because we didn't do the document production, and the client turns around and says to me, why didn't you do this? You see, that's a problem. And so that's why you need to have a collaborative relationship between the outside counsel and the in-house counsel or the party representative. You know, I can say to a client, look, there's a 15% chance of this, it's going to cost this much, and so on. Let's sit down with open eyes and decide whether the cost is worth the risk and the result. And you make a decision, and then you live with that decision. Make the best decision. And in fact, I submit again to you that the appropriate time and cost decisions are made when party representatives have a collaborative relationship with outside counsel, and when the in-house counsel or the party representative actively participates in the making of those decisions. Because as I say, in many cases, they are more business decisions than legal decisions. And after all, it's the party that has the best knowledge of its own goals, the value of the dispute, what is ultimately at stake. And the party should be in a position to decide how much cost it should incur in relation to the benefits that it is likely to obtain. And after all, you know, it's the party's case, the party's risk, and the party's money. And so the party needs to be brought into the process and play an active role in this decision-making in order to ensure an efficient process. And of course, outside counsel can help in the making of those decisions by explaining and helping to determine what the risks are and what the benefits are. And arbitral tribunals can also bring their experience to bear in devising these procedures based on their experience. Now, again, the need for this decision-making process is particularly necessary in arbitration because, as I've been saying, the rules don't specify the process, and it needs to be looked at and carefully developed. So now that leads to the next big question. For the party representatives to play this role, of course, they have to have a good understanding of what the procedural options are. They have to understand the pros and cons of these options. And they have to be able to determine the cost-benefit implications of the various options and choices that there are. Now, a number of large corporations, and I know this from working with them, have developed their own methodology for party involvement in these decision-making processes. And they have a whole protocol that they use. But they are, you know, the companies that actually have this in place are the minority, the small minority. Most of the parties either leave the choices entirely in the hands of outside counsel, either because they don't have sufficient knowledge or they feel they don't have sufficient knowledge, or they don't want to take the responsibility. And so, left in the hands of outside counsel will feel the obligation to do the maximum, and it can't be otherwise. And so, when I was spearheading all of these activities at the ICC, I said, well, it's incumbent upon us to provide the parties, to provide the party representatives with a toolkit that they can use actively to play a role in this decision-making process. And so I came up with the idea of creating this guide, which we produced, which I'm author of, although I had a team helping. And the idea of this guide is to empower in-house counsel and other party representatives to play an effective decision-making role in setting up each arbitration so that the time and cost of the arbitration, as we said, will be commensurate with the value and complexity of the dispute. And it also serves actually as a useful checklist and tool for outside counsel and for arbitrators. There's a copy of this guide that's been made available. Some of you I see have it in your hands, but it's there, and you can take a copy with you. As I say, this guide is not a reference material to put on a shelf and forget about. It's supposed to be something to be actively used in the process of an arbitration. And so I would like to now lay out for you the methodology of this guide and how it can be used in practice, so that when you leave here, you can take it with you and know exactly how you can use it if you choose to do so. Now, the guide starts with a general introduction, and in this general introduction, it lays out more or less what I've just told you. This whole problem of how to focus on the cost-risk-benefit analysis. And then there are two introductory sections, and these are very interesting and very important. The first introduction section deals with settlement considerations and provides guidance on when it could be appropriate to settle the case, and it discusses the various methods of settlement. Now, what we say in here, and something that I always advise clients, is that settlement should always be considered, both prior to and during an arbitration. It should always be considered. Why? Because settlement is the fastest way to resolve the dispute. And it's clean and it's quick. But the advisability of a settlement will depend upon each individual case. You will have to weigh certain factors in determining whether in this particular case the settlement is a good solution. For example, you have to weigh your best judgment of the chances of success against the amount that the other side may be offering you. If there's a disconnect between that, the settlement is not a viable solution. Maybe you can negotiate towards it. But if you think you have a 75% chance of success, and they're willing to settle for 90% of their claim, something doesn't sound right. And so you may not want to settle on that basis. On the other hand, you may want to avoid the costs of arbitration. You may want to avoid the burden caused by the proceedings, the time you will have to spend. There are matters of principle, or you may want to eliminate uncertainties, financial uncertainties. You know, if you settle the case, then you don't have to worry in your balance sheet about contingent liabilities and things like that. That may be a consideration. It may be important to preserve a relationship with the other side. And by settling, you are more likely to preserve the relationship than by going to the end of the litigation. These are all factors. But on the other hand, settlement may not be a good idea if there's a principle at stake and you need a precedent. You want to be able to have an award. Maybe there are 20 other claimants in the wings waiting to see how this case will be decided. And and if you settle this, they're all going to come and want a settlement. That may not be desirable. So, also, there are some cases where, for political reasons, a party may not want to settle. This is particularly true of states, but it can be true of corporations as well, because they're concerned that their shareholders or that the public will view the settlement as an admission of liability, and they'd rather lose in an arbitration and say the arbitrators were wrong than settle the case, which could be interpreted as an admission of liability in some cases. These are all these factors that have to be taken into account. But the bottom line is that an appropriate settlement will always be the fastest and most efficient way to resolve a dispute. It should always be considered, and these various factors need to be weighed to see whether in your particular case there is a settlement solution that is appropriate and effective. Now, the second introductory section in the guide lays out and explains the importance of holding what we call an early case management conference. And the early case management conference is a meeting between an arbitral tribunal and the parties, counsel, but party representatives should always attend these case management conferences if they're going to play an active role. because it's at the case management conference that this tailor-making process will occur. It's at this conference, which will occur before the procedure starts, where the parties either will present the tribunal with what they've agreed upon, and the procedural order by the tribunal will take into account the procedures agreed by the parties, or if they disagree, that's where they will present the tribunal with their different points of view on the procedure to be followed. Subsequently, the tribunal will decide and enter it in the procedural order. And so that's the mechanism which allows this tailor-making process that I'm talking about to come into play. After these two introductory sections about settlement and the case management conference, the guide presents a series of what we call topic sheets. There are 11 of them, 11 topic sheets. And these topic sheets are laid out, and we work very hard to do this, I must add, a user-friendly executive summary format. We did not write these topic sheets for academics or even for lawyers. We wrote them for intelligent business people who may not even be lawyers, or may not even have that much legal background, or have it, so that this would be understood by a CEO or by anybody in the business who could get a sense of what the choices and the options are. And so each one of these 11 topic sheets deals with a key step in the arbitration process where these cost-benefit decisions that I'm talking about need to be made. And each topic sheet is designed to serve as a tool to practically assist in the making of the appropriate decisions with respect to the topic concerned. And as you will see when you look through the guide yourself, the topics include the key steps: request for arbitration, answering counterclaims, multi-party arbitration, rounds of submissions, early determination of issues and bifurcation, document production, fact witnesses, expert witnesses, the conduct of the hearing, and post-hearing briefs. And all these things that are not dealt with in these rules, this guide lays out the options with respect to those steps. And all of the topic sheets follow the same format so that they can be used in parallel and by comparison. And they're divided into separate sections. The first section presents and explains the topic under discussion. The next section enumerates the available options with respect to that topic, and we try to be exhaustive with respect to that. The third section discusses the pros and cons of each of the options. And the fourth section presents the famous cost-benefit analysis of the choices that can be made. In the fifth section, we give a list of questions, of useful questions to be asked with respect to the topic. Now, this list of questions is really the key element that's designed to empower the party representatives. Because you can take this list of questions and go to see your outside counsel and say, well, you know, the ICC has produced this thing on this particular topic. There are these questions. Let's go over them together. Tell us what you think. Should we do this? Should we go through the questions? And it gives the party representative both the means and the authority to raise these issues with outside counsel. And I must say, speaking for myself, when I have a client who takes this approach, I am very happy, because the best arbitration is one where the client and the outside counsel are working together, and where the outside counsel can benefit from the client's decision making and from the client's knowledge of what happened, which, you know, the outside counsel can never have to the same extent. And finally, the sixth section, when relevant, there's a section that raises other points to consider, collateral issues with respect to the topic. And so, with these topic sheets, you have within your hands the means for making decisions with respect to each of the topics. Now, it's important to note that these topic sheets are not prescriptive. They're not going to tell you how you should decide the questions. They tell you how to go about deciding the questions, because the question has to be decided in light of the facts of a particular case. And there's no way a guy like this can tell you whether you should have 2 rounds of briefs or 1 round of briefs. But it can tell you what factors to look to make your decision as to that point. And so let's jump right in now to the heart of it and illustrate what I've been saying somewhat abstractly by taking example of 2 topic sheets, and let's walk through them, and I'll show you how this is designed to help you, how this is designed to work. And so we'll look at topic sheet 5, which concerns the number of rounds of written submission. I chose that one because in a way it's the simplest, and it enables me to show you very clearly the methodology. And then topic sheet 6, concerning document production, which is certainly more complicated, but it is interesting as an example because it's an area where you can save a lot of money if you do it properly. So let's turn now to the topic sheet number 5, find it here, on the issue of how many rounds of written submissions you should have. Again, first point, there is no knee-jerk answer. The rules don't require any number of rounds of written submissions. The arbitral tribunal comes in with procedural order number 1 automatically with 2 rounds and this and that. Not necessarily. It can be otherwise because the rules don't require anything to be expected. And so the first section, as I described, lays out the issue to be decided. How many rounds of written submissions are appropriate for this case? And then the next section lays out the options. Option 1, no further written submissions. Maybe the request and the answer or the initial pleadings in some cases may be sufficient. It's enough then to go straight to a hearing and then maybe have post-hearing briefs. Why not? That may be the right thing for some cases. Or, next option, 1 round of submissions after the initial pleadings. That may be enough. Or 2 or more rounds. These are all possible options. So the second section lays them out. Now the third section discusses the pros and cons of these various options. And of course, additional rounds of briefs may actually be necessary to enable the parties to further articulate their positions and respond to developing arguments on each side, particularly in complex cases, or in cases that involve a huge number of facts or technical issues. However, in certain other cases, additional rounds may lead to unnecessary repetition. And I think we've all seen cases where the second round is just a rehash of the first round. Sometimes there's excessive detail, and sometimes even dilatory tactics. And so a cost-benefit analysis is necessary. And the principles for conducting that analysis are in the 4th section. And there you will find that it states that clearly each additional round of briefs will significantly increase the time and cost of the arbitration. And so it's essential to determine for each case whether the benefits of an additional round are worth the extra time and cost. This is a business decision. Now, they may well be necessary when there are complicated issues of moral fact, which need expansive debate. On the other hand, additional rounds may be repetitious and unnecessary. And sometimes there are tactical considerations. There are parties who hold back in the first round, and they really put all their arguments in the second round to try to avoid, well, that defeats the purpose of the first round, if that's what's going on. And so, taking all this into account, knowing who the other side is, how they're likely to react, you need to make a decision with respect to this. Now, the questions to be asked are laid out in the 5th section. For the question of rounds of briefs, the questions are really quite simple. Does the case justify the time and cost of each additional round of written submissions? Are additional rounds of submissions genuinely necessary for a party to make its case to the tribunal? It may be, or it may not be. What is the estimated cost of each extra round of submissions? And finally, is the expected benefit worth that cost? That's the ultimate question. Because, you know, if you're going to buy something, you want to be sure that what you're going to pay for it is worth the benefit that you're going to get from purchasing that thing. And the same thing is true with respect to arbitral procedure. There's nothing mystifying about it. It's a question of what you're willing to pay for the benefit that you reasonably expect to obtain. And so the final section on the rounds of submissions lists other considerations, as I described. Some of the other considerations are consider page limits for briefs. It's amazing how effective page limits can be. It forces you to really say what needs to be said. You know, you can't just go on and hope that somewhere in the brief there's something that might convince the tribunal of something. If you're limited to pages, you have to have a dense, logical, and structured brief. In many cases, I have pushed for page limits. Well, partly because I know I can write a 50-page brief that will say what needs to be said, and maybe the other side won't be as good at it. These are tactics, but in the end, you know, it may be useful to limit the number of pages to prevent just going on and on. Also, keep in mind, you know, the outside counsel with in-house counsel, you might have a team of 15 people working on a big case. An arbitrator is one person, you know. If you give an arbitrator a 600-page brief and 50 cartons of documents, do you really think the arbitrator, him or herself, is really going to read all those 50 cartons of documents? Wake up! They're not going to read it. And so you're going to lose control because you don't know what they are going to read and what they aren't going to read. If you give them less, you can control what they're going to read. And that's also something you have to keep in mind what you're doing. Because otherwise, they're going to have the secretary of the tribunal, and you saw in the UCO's case, it was the secretary of the tribunal who actually did all the work, and actually even wrote the award, it seems. So you have to be careful not to have a disjunct between the effort put in by counsel and what you can reasonably expect the tribunal to do with what you're giving them. So that's the thing on the rounds of briefs and, you know, how much you should put into it, and that'll vary with the case. So now let's turn to the last example that I want to go over with you, and that's topic sheet number 6, document production. Now again, in the guide, the first section lays out the key issue. The key issue is quite simple. Is document production desirable for you? And if so, how much document production should there be? Now, one thing you have to always remember, each party always has the right to produce whatever documents it has in its possession. So this question about document production is really a question as to whether each party should have the right to require the other party to produce documents in its possession. And obviously, this type of document production, which is what we normally mean by document production, is going to involve substantial time and cost. So that's the question. Now, the second section lays out the options. Option 1, no document production at all. Now, you may have enough documents in your possession to prove your case. You can meet your burden of proof. You may not need any additional documents on the other side. And if there are very specific things that you might need, under the rules, you can always ask the tribunal to order a party to produce a particular document, because the rules always say, you know, that the arbitral tribunal has the duty to determine the facts by all appropriate means. So it may be that this reduced formula works for your case, and you'll save a lot of time and you'll save a lot of money. And the other side to this point, that you could have no document production at all, is something that a lot of people don't even seem to realize, particularly if they're not in this arbitration world themselves. There is nothing in the arbitration rules that require document production. It's permitted, of course, but it has to be either agreed by the parties or determined by the tribunal. And so there is no requirement, as there would be, say, in the United States Federal Rules of Civil Procedure or certain other procedural codes. In the arbitration rules, there is no requirement. So do you really need this expensive, time-consuming process? Can you make your case without it? Don't forget, if you agree to document production, it's not only that you're going to get documents from the other side, you're going to have to produce documents that you have. It may be that you think that what you have to give may be worse for you than what you think you can get from the other side. That's a tactical consideration. That also could lead you to say, maybe we're better off without document production. And then you can argue to the tribunal, look, it's faster, it's cheaper, we don't really need this. So that's the first option. And then the second option is you can agree to limited document production of only specific documents that are determined to be relevant and material to deciding an issue in the case, along the lines of the IBA guidelines on evidence. And so you can agree to a limited type of document production. Or the third option, complete document production, the fishing expedition, you know, everything. You can even agree to depositions and interrogatories. It's rarely done, but it's possible. And so the next section, the third section, lays out the pros and cons of these different options. Document production can be very expensive and time-consuming because for each document production, a party will spend, first of all, a great deal of time reviewing and studying and producing a whole lot of documents. And we'll also have to spend a lot of time and money reviewing the documents that the other side produces. So you get the time and cost both ways. And very often, hundreds of documents are produced in this document production procedure. And often, very few of them ultimately find their way actually into the arbitration proceedings or are submitted to the tribunal as evidence. So that's the one side, pros and cons. On the other side, of course, document production may be absolutely necessary for you in certain cases. If, for example, the other side, and this is more frequently the case than you might realize, the other side holds all the documents that you need to prove the case. You don't have them yourself. And so, in that situation, you may need and want document production. And on, the other sections follow the same pattern that I have described to you with respect to the round of briefs, and you can find them in the guide. And this same methodology that I've laid out for you with respect to these two examples applies to all of the other topic sheets that you have. And so to conclude this presentation, we go back to the beginning. To the extent that parties and users find that arbitration has become too long and too expensive, they are not powerless with respect to that. If they're working with outside counsel who understand this and are cooperative, they can sit down and make collective decisions as to what is the optimum procedure as a cost-risk-benefit analysis, and then try their best to either get the other side to agree or the tribunal to decide that. And then you will have accomplished the tailor-making process for an appropriate time and cost for your case that the arbitration rules were designed to give you. I thank you for your attention.
Peter, thank you very much for your very detailed and extensive presentation. It's actually to the good luck and the Russian tradition when the glasses are broken. It's very good. So good sign. Yes. Other people are frustrated or very happy. So the question it's now the floor is open for questions. The first question is from me. It's very detailed guide as you described, and covers many situations. However, the most popular situation is quite simple, where the parties have absolutely different intentions as to the procedure, continuity of procedure, the timing, and they take different views on this. You know, describing the same, basically the same facts, they put it completely oppositely. You know, one is saying that, you know, I need more time, and actually using delaying tactics, and you can guess who is that, the respondent most of the time. And the claimant pushes for the shorter period of time. And they describe exactly the same situation. So if you were arbitrator, what would you do if the parties are so opposite?
Well, I think this is the case where at the case management conference, each side is going to plead as to why they claim they need whatever it is they need. And depending on how compelling the arguments are from one side or the other, the arbitral tribunal will decide, and then both parties have to live with that. But, you know, I have had situations representing respondents where I was able to convince tribunals that we needed 5 months for our responding brief, and I have represented claimants where I was able to convince tribunals that 2 months was more than enough. But, you know, it's a question of convincing the tribunal and trying to amass arguments for why what you're arguing for is reasonable. You may win it or you may not, but if you don't try, you'll never get it. So it's always worth trying. And if you don't try to tailor-make the procedure, you don't try to agree with the other side, you don't try to convince the tribunal to adopt the procedure you want, then what's the chance you're going to get the procedure you want? Maybe very little. If you try, you increase your chance.
Okay. Okay. The questions to Peter from the audience.
Peter, can I ask you a question? Well, you mentioned military tactics, which are often used in arbitration. How a counsel can oppose these tactics? I mean, the only tool which comes to my mind is to ask the tribunal to impose costs on the other side. But it's sometimes it's not efficient. But sometimes the party understands that it may lead to additional costs, and it's agreed to take it, but it just proceeds to breach the deadlines and trying to avoid, the award. It's typical sometimes for arbitrations involving also Russian parties. So how would you advise to oppose that tactic?
Well, there are several things. First of all, you know, when I was in charge of revising the ICC rules of arbitration, we added some new provisions in here which give explicitly powers to the tribunal to actively talk to parties who are engaging in military tactics and to warn them in advance that if they do things that are considered dilatory tactics, even if they win the case at the end, they may find big costs against them. And we have encouraged tribunals to be more active in trying to prevent dilatory tactics. Now, of course, there's a difference between dilatory tactics, true dilatory tactics, and parties that are legitimately asking for things. But you can usually know what you do. So, on the one hand, I think part of the answer is empowering tribunals and encouraging tribunals to do that, because it's very hard for one party to stop the other party from doing something, of course. And as to costs, you're right. That's an important point. And if I have an opposing party that I think is going to be engaging in dilatory tactics, I will, and if the tribunal doesn't say anything, I might even in the first session say, look, tribunal, do you have any views as to how you would apportion costs if either of us engage in dilatory tactics and try to push the tribunal into, taking an active role with respect to this? And then another thing that I do is, usually at the end of the case, you have to file a statement of costs. As the case goes along, associates keeping a list of dilatory tactics. Every time there's one, we write it up right then, and what was the reason and what was the thing. And then in my final brief on the statement of costs, I bring all that in, and I said, here are all the dilatory tactics. So, to answer your question, there's no miracle answer to it. You have to rely on the tribunals. You have to make clear what these are. Also, state them as they go along, and then bring them up in terms of the cost base. If it gets really bad, you could ask for provisional measures against certain dilatory tactics. That would be an extreme situation, but I've done it. So, it's true. You don't have a huge panoply of tools to deal with dilatory tactics, but there are some, and they can be effective, particularly if you can get the tribunal to take action.